ultimate occupant violation of lease. We did, but the one thing we said we were doing in the situation. That's right thing to say. Okay.
Mhm.
Okay, let's see if we can shorten this up. The tenant stated he has left and wants to submit applications. Okay.
No, but
Well, the hotels are open, but if you have children or dogs, I mean, it's, so it's just a mess. And I just begged, I am personally paying for some people, to some sellers. I mean, I don't even want to mention the amount, but for the sellers to let a buyer take possession before closing because it's delayed. I mean, normally here it's, $35, maybe $50. It's up to $150 a day.
and the sellers have someplace to go, the new place that they've bought.
They have a place, they're leaving the area, but the buyers don't. So it's,
Right.
and trucks. I mean, trying to get a U-Haul truck, it's almost impossible because they have to be cleaned. So, and U-Haul would not, if you cancel, it's very hard to get your money back, even due to a situation because there's been a change in the move, it's been delayed. That part, the struggle with moving trucks, there's just, oh, and the prices have just skyrocketed on that too. Of course, we're in the Coast Guard community, and the Coast Guard people weren't sure if they would be moved. They just decided last week they would actually, the Coast Guard people, so many Coast Guard people packed up already. They've packed, and now they've learned that the Coast Guard people the Coast Guard crew will come and pack them, so they're going to have to unpack and repack. But the trucks were all taken up. I mean, it's just the logistics in a rural area, and I'm sure it must be worse than a metropolitan area where there's, even more people, but the cleaning of the trucks is something else. I mean, and it takes a day or two. So it's just trying to make people understand, and they just don't understand,
All right, we are live on our closed Facebook group right now, and we have about 30 people online with us right now. So I think we're going to go ahead and get started.
Okay.
Thank you, everybody, for joining us, and thank you, Will Martin. Will is our local association counsel, as well as NCAR's legal counsel. And how long have you been legal counsel there, John? Will?
Since 1996. So my, I guess 24th anniversary will be coming up pretty soon.
Wow, long time. And Will answers some of your questions on the legal hotline and writes the legal Q&As that get sent out every week. So he has a lot of knowledge that will be very helpful to us today. And Donnie is here, Diana Gardner, our president, is here, and she's going to ask the questions that have been submitted. If anybody has any questions along the way, you are welcome to put them in the chat box, and we will go over those at the end. And if you're watching us on Facebook, you can put them in the comment section of Facebook, and I'll read them as well at the end. So Donnie, take it away.
Okay, thank you, Colleen, for arranging it, and thank you to people for submitting the questions. I know Colleen's phone, my phone's been ringing, and I'm sure, Will, you've gotten a few calls over the past couple of weeks too.
Yeah.
Let's start with the first question. It says, we understand evictions for non-payment of rent are suspended due to the virus situation. What about other violations? This person's asking about what do we do if a tenant has an unpermitted occupant in violation of the lease? The tenant has left and wants to submit an application to have this person added to the lease, but no application has been submitted to date. What are the options regarding an unpermitted person? Since we know what's in place for the regular tenants, but what about an unpermitted person or other violations?
Yeah, it's a good question. Before I try to answer the specific question, just a little bit of background. We're really dealing with two main things and maybe three things when we're trying to analyze these landlord-tenant questions. One is the Chief Justice of the North Carolina Supreme Court, Justice Beasley, issued an order back in March closing the courthouse, or not the courthouse, but the virtually all court proceedings have come to a halt. That's been extended through the end of May. And that includes evictions, or at least the vast majority of evictions, there was some room in there for emergency proceedings, but we haven't heard of any that would be considered an emergency eviction. But there could be a circumstance. So that basically has shut down all evictions. Under there was some federal legislation, one of the stimulus bills, the CARES Act. If there's a federally backed mortgage on the property that's being rented, then the CARES Act applies, and there's a moratorium on evictions for non-payment of rent. So it only applies to non-payment of rent, but there's a moratorium in effect that, practically speaking, will not permit you to evict somebody for non-payment of rent until about August 24th, I think. And that's only if there's a federally backed mortgage on the property. And so if you're a property manager, you want to find out if you're from your owner, who may need to check with somebody. Apparently, it's fairly easy to determine whether or not your mortgage is a federally backed mortgage. If it is, that's going to affect your ability to evict somebody or even notify them of a default for non-payment of rent, regardless of when the courts reopen, which we're hoping will be June 1st. But this particular question didn't have anything to do with non-payment of rent. And so it's not covered by the CARES Act, even if there is a federally backed mortgage on the property, because it doesn't have to do with non-payment of rent. This would be for an unpermitted occupant, which is not an uncommon question on the hotline. So because the courts are closed until June 1, we think, you're not going to be able to actually schedule a hearing, a summary ejectment hearing, to have this person evicted. You could actually notify them that they're in breach of the lease, and probably you should, and you could actually terminate the lease. It's just that you could terminate the lease and demand possession of the premises. But if they refuse to give you possession, you don't have a remedy until, probably June 1 or after June 1. One of my partners wrote a Q&A, multi-question Q&A for a publication we contribute to that the NCPMD puts out quarterly. And he did an extensive Q&A on this very topic. So if you're a member of the PMD, you may have seen it already, and I would commend it to you. I've actually got a copy of it here in front of me. But Bill points out in his Q&A that one of the questions that we have come up is, does it make any sense to file an eviction now, even though you're not going to be able to actually have the case heard until sometime after June 1? And he checked with several clerks of court around the state. And his sense is that there's really no disadvantage to, or there's no advantage to waiting to file. If you've gotten to the point where you've decided you're going to evict somebody, and that may or may not be the case in this first question, but when you get to that point, you can go ahead and file. And in some counties, you'll be given a court date in the order that the cases are filed. And I know that's the case in Forsyth County, where I am. But apparently in Mecklenburg County, we understand that the clerk isn't notifying the filing party of hearing dates for their newly filed cases. So you don't know, when your court date's going to be, or if you're going to get some priority court date based on your filing. So there's a lot up in the air, but you can go ahead and file, and you may want to check with your clerks in your own county to determine whether or not filing makes any sense now, even though you won't be able to have it heard until until later. So let's see if I've answered the question here. Yeah, I mean, an unpermitted occupant, that's a difficult situation anyway. If they're not, you know, I've told people that there may be some criminal charge that could be taken out, a criminal summons for something called second-degree trespass. And so I don't know. I know a lot less about what kind of activities going on the criminal side. I know the courts aren't completely shut down, but I think maybe they would be hearing more serious criminal cases. I doubt this would arise to that level. And I don't know if it'd work anyway, but the idea is that if you've got an unpermitted occupant, even though they may have entered at some point with permission, you can take that permission away. And if they've got no legal basis for remaining, then that forms the basis of a second-degree trespass charge. So somebody might try that, but I'm not too sanguine about that working in any event, much less under the circumstances we've got now. So it's tough. It's a tough situation to deal with.
Well, thank you on that. Our next one, we have many homes that are for sale, but that are currently tenant occupied. So many of the agents have been using the virtual tours, et cetera, to showcase it, still photos. So what if you have a buyer who's seen the virtual tour, seen the photos, maybe looked on the exterior, but wants to make an offer, but wants to be inside, but the tenant says no, because the buyer is, I don't want anybody coming into the house. Any suggestions for a workaround, or does the tenant have a right to deny access due to this unusual circumstance?
That's another great question.
Great questions from Albemarle.
A messy answer,
Oh,
you know, part of the answer is going to depend on what form of lease was used, but assuming that the standard residential rental contract is used, you know, the landlord reserves the right to come onto the property for certain permitted purposes, and showing it for rent or sale, I would say, is certainly a permitted purpose. And so, you know, ordinarily the tenant would be in breach if they didn't allow the, you know, showings to take place. And that happens under regular circumstances occasionally. It's a difficult situation. But I would say, we've been saying on the hotline in response to that kind of question that we don't think it's reasonable for the tenant to deny all access to the property, that there are reasonable ways in which to minimize the possibility of, you know, spreading the virus, and that if the tenant refuses to show the property under those kind of circumstances with plenty of notice and you know, assurances about, you know, cleaning and that kind of thing, then I think they're in breach of the lease. But, you know, your remedy for breach of the lease is to terminate the lease and evict them, you know. And so we're kind of back to question number one here. But, you know, you do have the right to notify them they're in breach and to terminate and demand possession. And it may be that, you know, if the tenant begins to see that you're serious about it, they might back off and agree to something reasonable. I certainly wouldn't recommend that you just schedule a showing and just show up. You know, that's, you know, if you can't breach the peace, and you would never want to enter leased premises against somebody's will. That's going to put you in a bad place, and so I wouldn't recommend you do that. So again, it can be a very difficult situation, but legally speaking, I think the landlord has the right to enter the premises for purposes of showing it for sale.
so they had, again, they had the right, but not a recourse during this current situation.
Right.
Well, it looks like our next question is going to be that answer also, because it says, if a tenant is in a month-to-month lease situation in a house for sale and the tenant will not move, what recourse does the seller have to gain possession? So it's basically the answer that you gave above, correct? That
Yeah, they're a holdover tenant and they can be evicted for holding over, you know, if the lease permits it, which certainly the standard lease does. But yeah, again, you know, you could threaten them and demand possession, and you could actually file the eviction and have it served.
Mhm.
And, you know, maybe that's enough to get their attention. But at the end of the day, you know, you're not going to be able to have the case heard until, you know, sometime in June, hopefully.
Okay, well, thank you again on that. Next one is about a gated community. We do have an area that's a gated community, and the board of directors of that community have decided to close it, including the firm that's located within the community and potential buyers. And it says, can you comment on the HOA's reaction? We have many members who don't believe they should be allowed to keep agents/people out of the gated community.
Yeah, I would tend to agree, probably. I talked with some of y'all may know Jim Slaughter. He's the NC Realtors parliamentarian. He shows up at all our board meetings and sitting there right beside the to the right side of the president during our meetings. Jim's firm does a lot of. They represent a lot of HOAs across the state. And I had that question once, something like that, not too long ago. And I talked with Jim about it, and he said he'd be very skeptical that they had that right. And if they did have any kind of right, it would have to be included in their, you know, in their covenants that are recorded. But that it's very likely they don't, you know, they're going beyond what they're permitted to do. So, you know, the question is, what do you do about it? You know, ordinarily, if something like that, I'd say, well, if they persist in this, you know, you might have to, somebody who's been harmed by it might have to file a suit and ask the court for a temporary injunction prohibiting them from doing what they're doing. Well, this access to the courts right now is, you know, it's not likely you could get something like that heard. So
we're back. So basically, from what you're saying is that unless this is somewhere, and you mentioned in their covenants, what if they had bylaws, the HOA had bylaws that said they had a right to restrict it? How would that be the same as the covenants? I mean,
that's a
in
more
that sense?
technical question. I think generally it's got to be in the
Recorded covenants.
declaration or covenants, you know,
Okay.
so that, you know, you would have notice of that as a purchaser. I think you'd have to be on constructive notice of that, and just simply putting it in your bylaws I don't think would be sufficient. Even if they've got it, you know, it's a question about whether or not that's even permitted by the law, you know. But for starters, if they don't have it, they don't have the right to restrict people according to their governing documents. Then they're right there. They're going beyond what they're permitted to do.
Okay, well, thank you.
Donnie,
Yes,
we have somebody who has a question. I'm gonna
go ahead.
ask Jennifer Elmore. I'm gonna let you talk so you can ask that question. Let me unmute her. Maybe.
She's
Jennifer?
still muted.
Jennifer, can you unmute yourself?
Hello,
Hi.
Hey,
how are you? My question was, if courts are not accepting any unlawful detainers or any type of paperwork, how can we file for an eviction or anything if they're not accepting the paperwork?
well, my understanding is you can still file the paperwork. You just can't, you know, it's just not going to be heard in court.
Okay. All right, thank you.
Welcome.
Any other ones, Colleen?
No, not right now.
Okay. The next one is if a landlord has tenants who are not paying their rent because of the relief provided through the CARES Act, is there any relief for the homeowner as far as mortgage payments? Which we see, that's probably a frequent question also.
The answer is yes. I'm just going to read a little bit of Bill's Q&A that I referred to earlier. The CARES Act does provide some relief for landlords as well as tenants. Sections 4022 and 4023 of the CARES Act give owners of single-family and multifamily properties with federally backed mortgages the right to seek forbearance from their lender. And in a footnote, he says, in the context of a loan, forbearance generally refers to the postponement or reduction of loan payments. So if you have a federally backed mortgage on your property and the tenant quits paying their rent and that messes up your cash flow, then you have the right to seek forbearance from your mortgage lender. And the rights are vary just a little bit depending on whether it's a 1 to 4 bedroom. Let's see. No, for single family properties, yeah, relief is governed by section 4022. Upon receiving such a request, or the request being that the borrower was experiencing a financial hardship during the COVID-19 emergency, and then when the lender gets that request, they must grant forbearance for up to 180 days, and that period may be extended upon the borrower's request for an additional 180 days. So that's a year. Now, understand that if you seek forbearance from your lender for a year, it's kind of a two-edged sword. You're still not going to be able to evict your tenant for non-payment of rent if you're taking advantage of the opportunity to get forbearance from your lender. So it kind of works both ways. And then for multifamily properties, section 4023 applies. Relief is limited to borrowers with loans that were current on their payments as of February 1. It's granted upon receipt of an oral or written request, affirmation that the borrower is experiencing a financial hardship during the COVID-19 emergency. The initial forbearance is limited to 30 days, but can be extended for up to 2 30-day periods upon the request of the borrower. So that's a total of 90 days that you can get forbearance, or that your lender would be required to give you some kind of forbearance if it's a multifamily property. So it's a little bit more limited. But there is relief available.
Thank you. The next question is, it says, a neighboring MLS has created a communicable disease release and hold harmless agreement in response to the COVID-19. Is there any discussion of creating one for North Carolina?
The short answer is no. There really hadn't been any serious discussion about creating something like that. And this has been an issue of, it's been a hot topic among state association attorneys that represent, state associations of realtors. There's been a lot of discussion of this topic on a listserv that we participate in. And there's some associations that have developed things that maybe looked something like this form that I was sent a copy of, that I've got here in front of me. And then some have not. And the National Association has recommended against it. And that is consistent with my view of it too. This form, it looks like it was designed so it could be signed by a seller or a buyer or a landlord or a tenant or a real estate agent, maybe showing a prospective buyer a property. And they're representing that, to the best of their knowledge, they're not currently afflicted with COVID-19 or any other communicable disease. they're not experiencing certain symptoms of a communicable disease, and they're agreeing to release and hold harmless everybody on the planet Earth, it looks like, from any kind of claim relating to contracting any communicable disease in any way related to the property or the properties. You know, why don't I favor these things? For one thing, I don't think it's necessary legally. I mean, it would be very difficult to prove where you got the virus. You know, if you contracted it, how are you going to, you know, and the symptoms don't manifest themselves for sometimes a couple of weeks. How are you going to be able to prove where you got it, for one thing? I wonder about the enforceability of something like this. I mean, let's say you've got a property that's under contract, and we get these questions. It was under contract, and now the seller doesn't want to allow access to the property. You know, I think the buyer's probably got a right to go onto the property, a contractual right to go onto the property. And so, you know, what if they refuse to sign this document? What are you going to do? I mean, or what if you're not under contract and, you know, you're the listing agent and you've got this form now, and is the seller actually gonna prohibit somebody from coming onto the property if they don't sign it? Even if they do sign it, is it really enforceable? You know, certainly if it's under contract, I think as I said earlier, the buyer's got a right to go onto the property to investigate the property. And so what are they giving up? I mean, they're agreeing to release and hold harmless anybody. I think it's an illusory agreement, perhaps, you know, that's not going to be enforceable at the end of the day. And, you know, there's also a real estate commission rule. I don't know that it's directly applicable here, but I printed out the rule here. There's a rule that has a laundry list of things that are supposed to be in a standard sales contract. And there's a section at the end that says a broker acting as an agent in a real estate transaction should not use a pre-printed offer or sales contract form containing, there are two things. One, any provision concerning the payment of a commission to a broker. Everybody knows about that one. You know, you can't put anything add anything to your offer about a brokerage commission. But then there's a second thing, is any provision that attempts to disclaim the liability of a broker for his or her representation in connection with the transaction. Now this rule, if you read it narrowly, only applies to pre-printed offers and sales contract forms. And this form I've got in front of me is not an offer or a sales contract form. So you could argue that this rule really doesn't apply to that, but it's pretty doggone close. You know, you're using this pre-printed form in connection with a sales transaction or a possible sales transaction, and it attempts to disclaim your liability as a broker. So that concerns me a little bit. I mean, the real estate commission might say, well, we don't think that's applicable. So one of the big problems I have with it, I think it might give people a false sense of security. I've dealt with this over the years, not in this particular context, but brokers are oftentimes fond of getting some kind of hold harmless agreement signed just for, you know, all kinds of things. And usually it'll be like a disclosure thing. There's one part of the state where there's kind of a standard form been floating around for years where, you know, you give to a buyer. Sometimes you see it added to a sales contract form where the buyer is advised in a very general way of the existence of certain things that might possibly be material to the property. You know, hey, we have airplanes in Western North Carolina, and we have trains, and there are roads all over the place. And, you know, we've got some Superfund sites. You know, be advised of the existence of these things, and you better check them out. And, you know, that's fine as a general sort of a disclosure, but my fear is that agents might think that, you know, let's say there is a property that is in the flight path of an airport, you know, and so there really is an increased incidence of noise that has an effect on the property. You know, simply giving somebody a general disclosure saying, you know, there might be an airport around here somewhere, you need to check it out. You know, if you think that's all you got to do, then you're wrong. You know, you've got an obligation to disclose the information, the material facts about the property, in this case, the existence of that noise that's going to affect the property. And you're not off the hook because you know, gave somebody this general disclosure. And I sort of have the same feeling about this, that, you know, people may think that, oh, well, we got this indemnity and hold harmless, we ain't got anything to worry about. And I think what people really need to be focusing on is trying to think of ways to accommodate the parties, you know, in creative ways, some of which might involve, you know, virtual showings, virtual tours, or focusing on making sure that protocols are followed regarding cleanup, or, you know, cleaning up, sanitizing, high-touch surfaces, that kind of thing. That, to me, that ought to be the focus, not so much, you know, trying to get somebody to sign something that you think is going to protect you. So, sorry, I got on my soapbox a little bit there.
All right, how about I give you a simple question? You ready for a simple one?
Yes, I can turn a simple question into a complicated one, though. So
This should be simple. I'm hoping. I'm going to skip. How many backup contracts are we allowed to have on a property? Pick a number, Will.
infinite number.
Infinite.
Yeah, I mean, technically, I mean, I can't think, if you get beyond much more than about one, you know, that it's going to be very practical. But there really wouldn't be anything theoretically that would prohibit you from having a, you know, a 10th backup contract that would be contingent on the first 9 contracts in front of you going away. You know, I mean, you could draft something like that, but it'd just be kind of ridiculous, I think.
Okay. Well, that was your intermission. Now we're going to go back to the complicated ones.
Thank you.
Gave you a break there for a moment. Here we go. If a buyer and seller are under contract, the seller is in the military, you know, Homeland Security, and orders to move are on hold, so then that seller cannot or doesn't want to sell on the contract date, is the seller in breach of contract? And what are the seller's obligations to the buyer? And I guess in our area here, we have a heavy Coast Guard presence and Navy and others. And so there was a period of time here where they were on hold as to whether or not they knew where they were going, but they didn't know if they were going. So can you address that? What would you do for that?
Yeah, that's a hard one, but I'd say as a general rule, you know, that seller is going to be in breach of contract if they fail to perform because they have difficulty moving. There's no reason why they can't close, just it's not impossible for them to close. And there's a doctrine in North Carolina, there's the doctrine of impossibility and the doctrine of frustration of purpose, it's called. And the doctrine of frustration of purpose, I'm just reading from a court case that I pulled up this morning, preparing for this presentation. The doctrine of frustration of purpose excuses a promisor, that'd be the seller in this case, in certain situations where the objectives of the contract have been utterly defeated by circumstances arising after the formation of the agreement. and excuse is allowed under this rule, even though there is no impediment to actual performance. And so actually, the first question I would ask, we're now, what, 5 or 6, how deep are we into this? It was about the
3 years.
the COVID-19, really, it was when about the time
Mid-March.
the SEC tournament got called off, and
March 12th.
yeah,
March 12th,
somewhere
yeah.
around in there, that's when it all kind of really hit the fan, and we all realized, gosh, this is for real. So we're, more than 6 weeks, we're close to 2 months into this thing. I mean, if somebody enters into a contract today and then tries to say that if they're trying to use this doctrine, which is kind of got 2 elements. One, there's got to be this unforeseen event that causes, the purpose of this contract to be frustrated or even impossible to perform. You're going to have a hard time today convincing anybody that if you entered into a contract today that the fallout from the COVID-19 pandemic was unforeseen. We know about it now. But if this contract was entered into, before this pandemic really manifested itself, you might have an excuse from performance, but I think it's a very high standard. And so if it's possible, it's not impossible, then you're going to have to show that the objectives of the contract have been utterly defeated. And, in the situation you describe, Donnie, I don't think it rises to that level. I mean, it's going to be a hardship for the seller, right? If they have to close and they don't know where they're going to go, right?
Right.
Yeah, but I mean, I don't think that utterly defeats the purposes of the contract. The purpose of the contract was to buy and sell the home. That's still possible. It is going to be burdensome for a party, in this case, the seller. But I doubt that would relieve the seller from the legal duty to perform. And so if the seller didn't perform, they would be in breach of contract. And then the buyer's got an interesting choice to make. They can terminate the contract and demand damages, which is at the very least a refund of due diligence fee if one was paid, due diligence costs, maybe other costs associated with the seller's breach that are directly related to the breach and were sort of reasonably foreseeable damages. Or, this buyer, depending on how badly they want the property, they don't have to terminate the contract. I mean, they can seek to enforce the contract. It's called the remedy of specific performance. And so they could, depending on how long the seller is delayed in their move, they could try to keep the contract alive. And sort of stated a different way, sometimes we get a call that people seem to think that after the 14-day permitted delay period in the contract, that the contract becomes null and void. That's just not the case. It becomes terminable at the option of the non-delaying party. But in this case, the buyer's the non-delaying party. They could elect to try to enforce the contract and keep it alive and force the seller to perform the contract. Of course, the courts are closed, so you could file the suit, but and serve it, and those move along at a pretty slow pace, and it may not be something that the buyer, practically speaking, wants to do, but you do see specific performance lawsuits from time to time in North Carolina.
Okay. This question is, as we are beginning to reopen offices, is it permissible for an office to set a policy requiring anyone who comes in to wear a mask? Is it okay or advisable to keep a list of people who come into the office so we can contact these people in case someone in the office becomes infected with it? Are there liabilities we should be aware of when deciding to reopen our offices?
That's a great question, and I reached out to the NC Realtors in-house counsel, Caitlin Thompson, who's been working a lot on the circumstances, anticipating that the state association's offices are going to reopen one of these days. Everybody's working remotely now, and trying to plan for that. And so Caitlin's been studying this issue in depth. And of course, you know, everybody at the NC Realtors, you know, is an employee. I'm not an employee. I'm an independent contractor, but most everybody that does work for the state association is an employee. And, you know, brokerage firms got a little bit sort of a mixed bag, I guess, of maybe a few employees and a lot of independent contractors. But I forwarded that question on to Caitlin and asked her if, you know, we had developed any guidance yet. And I'll tell you before I forget that apparently the National Association is working on something to answer this question. It should be available, I think she said, by the end of next week. So hopefully something comprehensive giving guidance to brokerage offices about reopening and the things they need to be thinking about will be available from the National Association pretty soon. Caitlin said the short answer to all the questions is yes. So, and then she says the long answer is complicated. And believe me, it's a complicated answer. I won't read her email to you, but there are an awful lot of things to think about when you're reopening an office, and you really need to be giving it a lot of thought. You know, I mean, there's some obvious things. You know, fewer meetings, Zoom meetings, no large gatherings, working from home. I'm just reading off a couple of things that I scratched down some notes here. One broker told me this morning, I was talking to him on the phone about something else, and he said, you know, they're really doing, they're doing appointments really at their office now. Their doors are closed, they're locked. And, you know, people really have to set up appointments to come into their office right now if they can't, you know, do their business, you know, remotely somehow. So they are accommodating people that really have a need to come into the office, but they're really kind of doing it on an appointment basis. You know, again, common sense things, you know, if your brokerage office, you're going to want to give thought to social distancing and limiting the number of people in rooms and giving people directions, maybe flow through an office, you know, like the kind of things you're seeing, you know, if you go to the grocery store now, that kind of thing, you're going to be wanting to do in your offices, you know, cleaning protocols. You know, one important thing is make sure that all of this is really clearly communicated to everybody who's going to be in the office or coming into the office. So, you know, having it written down and being able to, you know, clearly communicate, you know, having signage where appropriate, giving people instructions. But there'll be a lot more to come on this topic. But yeah, yes is the answer to all three questions that were asked.
Okay.
Those were my questions.
Okay. Well, let me tell you what, this is just fascinating to me what Caitlin said about masks. I had no idea that this could possibly be complicated, but she says, if you require masks, you need to have conducted a risk assessment, decide if you are obligated to pay for them, and then which type you need to provide. You absolutely have to have policies in place around those. If you determine through a risk assessment that respirator masks are not required, then your policy should say that. You might have employees who want to wear those. If you're providing disposable PPE, that's what, personal protective
Equipment.
They should have policies in place around proper removal and disposal. I attended a webinar recently where they recommended if employers were going to require cloth masks or make them voluntary, they provide at least 5 per employee so the employees can launder them once a week. If you provide or require any, you need to train people on how to use them properly. There are a lot of videos and infographics from the CDC about this. With masks, you also have to be aware of ADA accommodations if you are requiring them. Someone could have a medical or religious reason for not wearing one. So yeah, there's a lot to think about. But it's not impossible, you know, and we'll all get through this together. But
Okay.
Colleen, were there any other questions that came in during our
So
time?
I do have one question from the Facebook page, and if anybody has any questions on that sign into Zoom, type it into the question and answer box, and we'll read them. So Stacy has typed, even after the country opens up, don't you expect the hold on evictions and foreclosures will be extended? I know of a property that was about to go into foreclosure, and I expect it will be at least the fall before the bank continues the foreclosure process. Do you have any thoughts about that?
not really. I mean, there could be, well, as I said, you know, if you're operating, if the rented premises are secured by a federally backed mortgage, you know, it's going to be the end of August before you can begin to think about evicting somebody for non-payment of rent. But I just don't have a crystal ball about whether or not there are going to be further laws restricting the ability to evict somebody. You're certainly encouraged, and I know a lot of our members are working with tenants to try to, you know, do their own kind of forbearance with tenants, kind of restructuring their payments, really trying to work with them, or maybe providing them an early termination option that's, you know, attractive to them. And so there are a lot of things to try to do to work with them, and that you should be encouraged to do that. But, you know, I'm sorry, I just can't say whether or not there'll be more laws, you know, coming down the pike that are going to restrict your ability to evict somebody. It's certainly not impossible. Sorry, I don't have a better answer for that one.
All right, I just got another question on the Zoom webinar. Are external cameras allowed on vacation rentals?
When they say an external camera, I guess they mean taking a video of the outside of the property. You know, that's interesting. We're just we're making some changes to the standard residential rental contract, which is the long-term form, and we're addressing that for the first time, assuming it's approved. And I don't have any reason to think it won't be. Wherein we're requiring the landlord to disclose to the property manager, I guess this is in the property management agreement, actually, not the rental contract, the existence of any surveillance devices or devices that capture audio. And the owner is agreeing to remove them, disable them, or surrender possession of them during any time that a tenant is occupying the property. And I think we draw a distinction. I remember there's a discussion. We draw a distinction between cameras that are, or, you know, audio devices that are inside as opposed to outside, because, and I can't remember the exact wording that we came up with, but, you know, there were some examples given of how a landlord might have you know, a very legitimate reason for surveilling the exterior portion of a property, and the tenant really may not have a reasonable expectation of privacy in those more public areas. And so, you know, it might depend on, Yeah, it's just going to depend, but I wouldn't say, I'd say interior, well, I mean, even interior cameras, if the tenant knew they were there, I don't think I'd want to rent a place, you know, if I knew that the landlord was surveilling my activities inside the place I was renting. But if I knew about it, I don't think I could complain about it. And even it, you know, the audio could be captured, you know, if I knew about it. But I'm just not going to rent that place. And although surveillance, I think, is not necessarily illegal, although it could violate a reasonable expectation of privacy, capturing audio, a conversation between two other people without the consent of at least one of them is a state and federal crime, you know. So, and you see that reflected now in our agency agreements, our listing agreement, our buyer agency agreement, and we're going to include a note to that effect in the management agreement. We haven't done that in the vacation management agreement yet, but the way that usually works is the long-term people will add something, and then the vacation rental people will say, that's a good idea, let's put it in our form, and it works the other way too. So I wouldn't be surprised if you don't see something in the vacation rental management agreement, those of you who use it. Certainly no reason why you couldn't address it now. You'd probably want to hire a lawyer to draft something for you, but I think it's a good idea because these devices are becoming so ubiquitous that I think it's time to deal with those kind of issues.
Okay, I have two more questions, and both of them are about forms. The first one is, my question is about the new listing agreement and related forms that were released May 1st. When new forms are rolled out on July 1st, brokerage firms have a period of time to switch over and start using the updated forms. Is there a similar deadline for these forms rolled out May 1st?
Yeah, there's the 60-day delay period applies to the those two listing agreement forms that were rolled out May 1. You know, and you could continue to use them. I mean, I think it's a good idea to transition to the new forms as soon as you can. It's going to be, you know, mandatory soon. That shouldn't be confused. You don't have to, you know, enter into a new listing agreement if you've got one in place now, you know, before May 1. Some people get that confused sometimes. It's just on new transactions going forward. You won't want to use these forms at the latest after the, what would that be, end of May, end of June, I guess. But I don't see any reason not to start using the new ones. You know, the most important thing, the reason we rolled those out on May 1 was because of the clear cooperation policy that all MLSs had to implement at the latest by May 1. And we tried to change the listing agreement forms just so they would work a little bit better with that policy. But, you know, they don't, you know, the listing agreement form, if you think that using the listing agreement form is going to somehow enable you not to comply with some aspect of this new clear cooperation policy, that would be incorrect. You know, that went into effect May 1 on all new and existing listings, and you got to comply with that policy regardless of, you know, what the listing agreement might say. So.
All right, so the next one is, I may be late to the party, but have you spoken on the COVID addendum? Could you just say a little bit about the COVID addendum?
Yeah, I kind of got close to talking about it when I was talking about that, trying to answer that one question about the seller whose move got delayed, I think, because the Coast Guard was kind of putting a hold on the move, essentially. And it was my view that probably that seller would be in breach if they had the COVID-19 addendum attached to their contract, if the parties had made that a part of their contract, I might have a different answer because the standard is a little bit different. The way that form works is that if there's an issue related to the COVID-19 pandemic that makes it impossible or unduly burdensome for a party to be able to perform under the contract, then there'll be automatic delays for an agreed upon number of days. You fill in a blank, I think it's in paragraph 3, so that if the settlement date was today, and you've got, 15 days or 30 days inserted in that blank, then the seller can perhaps argue that, it's not impossible for me to complete my performance, but because of this delay in my move from the military, it really has become unduly burdensome for me to be able to complete this transaction. To me, that's a little bit different than what I was talking about earlier. And, it's subject to interpretation, but I think in that case, the seller's got a pretty decent argument that as a result of the COVID-19 situation, it's become unduly burdensome for him to be able to close on the settlement date. And in that case, it doesn't relieve him for performing the contract, but it will extend the settlement date by the agreed upon number of days. That might give the seller enough time to complete the transaction. If not, and if the parties don't extend it further, then the contract becomes null and void. And one of the effects of that addendum is that it kind of takes the issue of fault off the table, so that if you can't get it closed at the end of the delayed period of time, whatever that number of days is, then the parties are agreeing in advance that the buyer's going to receive their earnest money back and the seller's going to keep the due diligence money, and they're going to go their separate ways. So that's kind of how it works. We haven't gotten a ton of questions about it yet. Gotten some really dumb questions. I mean, I had somebody the other day that, you just can't anticipate how people are going to try to use these forms sometimes. But I had somebody the other day report to me that the buyer agent insisted that the blank, this agreed upon number of days, if you got if you have this triggering event happen, that you leave that number of days blank. And then when the event happens, then the parties agree on how long they're going to allow the delay, because you're not going to know until then how long you need. It's like, well, that just doesn't make any sense at all. I mean, what if they don't agree on anything at that point, So, and, if you got nothing in the blank, it really becomes very difficult to interpret what that means, what did they intend there? They just left it blank. I mean, I don't know, so we have gotten a few questions about that. So please put something in the blank. All right.
Hopefully that wasn't one of our members.
I know, I'm a little anxious here.
Yeah.
A little anxious.
I'll go back and check the area code, and I'll let you know
Okay.
what part of the state it came from. But yeah, so we hadn't gotten a lot of questions about it yet, and I don't know if it's been put out there in a lot of cases, and we're just going to kind of wait and see what happens, and maybe we'll start getting a lot of questions where transactions aren't working out, and everybody will want to know what their rights are, and but so far it seems like it's working okay. And one thing it did do, I think, is it just happened so fast. I bet I got 8 or 10 sort of COVID-19 forms that have been whipped up by lawyers all over the place, sent to me, and they're all different, and so at least coming up with one, statewide form that we agreed on with the Bar Association, I think helped maybe minimize the number of those things floating around so that, we're all at least interpreting the same addendum, and not trying to determine what the parties' rights are under 100 different ones, that people are drafting. So I think that was good that we did it for that reason, if no other.
Mhm. So we don't have any other questions on the chat line or the chat box or on
Oh, I just got
Facebook.
one quick question.
Okay.
Well, I don't know if it's quick. I'm trying to find a quick one for you, Will. Is there any movement among the attorneys to have the registers of deeds be uniform with some electronic filing for? Because that's the thing we've run into here. Some some counties have it, some don't. Some just for settlements. And so if we had it, certainly during something like this, it would be to a great advantage. Is there anything? Are your peers?
Yeah, there's been a lot of work on that for sure, and maybe this was in discussion before the coronavirus, and there's some very technical issues that lawyers are concerned about, real property lawyers are concerned about with electronic filing, and I used to do some closings many years ago, and you do your preliminary title opinion, and you send that off to the title insurance company, and you have your closing, what we call settlement now, and then you would go to the courthouse with the deed and the deed of trust, and before you put them on record, you would do an update. I would check and make sure that I'd check the temporary judgment indexes to make sure that no judgments had been filed against the owner of the property from the date that I had done my preliminary title opinion to the date I was recording. You would check the out conveyances to make sure that the seller hadn't conveyed some interest in the property, and it was rare that happened, but it can happen, and it does happen occasionally. And so in an electronic environment, it becomes more difficult to accomplish that. And I don't do transactions anymore. And so they're trying to work around that. And one approach is to have the seller sign a kind of an indemnity and hold harmless agreement and a representation that, nothing's happened in that intervening time, and that the title insurance companies are apparently okay with relying on that and issuing title insurance policies. And so, yeah, it's going to happen sooner or later. The other thing is, we've just gotten a remote notary, sort of an emergency legislation enacted that'll permit, I don't know if it's how much it's going to be used, but it'll permit a notary to actually notarize somebody's signature remotely. If they can't go to their house, because of some stay-at-home order. So, it's hoped that that'll ultimately turn into something permanent, that'll help facilitate electronic transactions, once we get past the COVID-19 pandemic. I don't know when it's going to happen, but there's a lot of work on it in progress for sure.
Well, let us know when this happens. We're ready. We're ready for you. We'll accept it.
Hey, before we sign off, I want to put in a plug for the hotline. I think Colleen mentioned it at the outset. Please feel free to. It's hard to call now just because there's nobody answering the phone at the NC Realtors, but there's a message there, and they give you the email address. So let me just give you the email address, and if it's something we really need to talk about because it's complicated, you, as some members do, just give us your phone number and we'll call you. But the email address is legalhotline@ncrealtors.org. legalhotline@ncrealtors.org. We're handling a lot of calls and questions, and be happy to talk with you, about whatever it is you all want to talk about, whether it's related to the COVID-19 pandemic or something else altogether. So just please feel free to use that service. It's a good service.
It is a good service. Your dues dollars at work.
My juice dollars are going to the tech line. Those people know me. When I come in, they just go, oh my gosh, she's there again.
Yeah, that's another great service.
It is
Tech
another
line.
great service. Yep.
Yes.
Yeah. We'll probably get about 5,000 questions on the hotline this year, and it just goes up steadily every year. So it's good service.
Well, thank you, Will. We appreciate you sharing your time with us. We'd offer you to come see us, but of course,
Where's lunch?
where's lunch? I don't know.
I know.
I know.
That's,
Yeah.
that's the only problem with these Zoom meetings. You don't get lunch.
How about a cup of coffee? A coffee would be good. I'm going for that. Okay.
Yep.
All right.
All
Well,
right.
my pleasure. Thanks a lot.
Well,
Thank you
stay
so
safe.
much.
All right.
Thank you.
All right.
Bye.